All right, welcome back to class. This is American Federal Government, and my name is Ken Hicks. Over the last couple of weeks, we've been dealing with sort of the constitutional branches of government. We spent some time talking about Congress and the powers that they have with all their legislative authorities. And then we talked about the presidency and the executive powers that accrue to the president and have made the president really one of the most powerful actors, not simply in American government, but in global governance. Then we started talking about the executive branch, which deserves to be considered separately from the presidency because bureaucratic power is significant. And now we're going to move on and talk about another important constitutional branch of government, and that is the federal courts. And it's important to keep in mind that the federal courts are really this is the institution that is most responsible for enforcing the rule of law. The whole idea of a constitution is that you are basically drafting out the rules of the game, and then you have to play within those rules. And that basically means that the federal courts, and especially the Supreme Court, have a powerful role to play in determining whether people are faithfully following the rules. Okay? So what are we learning today? First, we're going to talk about the basic purpose of a judiciary. The legal system is designed to handle disputes. Secondly, we're going to talk about the role that the federal courts play within judicial process. In fact, again, as is so often the case, we oftentimes misunderstand or misperceive sort of the overall size of the federal judiciary. While the federal courts are large and they cover the entire United States, most of the legal disputes in the United States are actually settled in state and local courts. And then third, we're going to start talking a little bit about the kind of the superpower of the courts, and that is the idea of judicial review, which is basically a filter that all government actions kind of have to go through, where you basically are looking, a federal judge or the Supreme Court or a panel of federal judges is going to look at a particular action by government and determine whether it is lawful or not, okay? So it's important to keep in mind first and foremost that courts exist and have existed historically because there need to be some collective means of resolving disputes. If you didn't have, if you imagine sort of a state of nature where everybody was on their own and everybody had to fend for themselves, people would handle their disputes individually. That oftentimes might lead to violence, and that is one of the reasons why we avoid those kinds of situations, because again, it can break down public order if people are carrying out feuds over who stole someone's goat or whether the property line was properly set between two neighboring communities. So courts originally referred to the idea of a place, where a monarch or where a feudal lord would sit, and again they would have people come to them and appeal for some sort of redress. Today, courts are comprised of venues where judges and lawyers settle disputes by, again, an impartial trial of facts related to a dispute. And again, whether a crime has been committed or whether some sort of relationship has been abused, that is going to be a matter of professionals who are expert in the law. If you are an officer of the court, you are basically, when you come into court, there are expectations that you actually have a case and that you are defending a person to the best of your ability. The essence of rule of law is that the state, however you want to define it, and its officials are judged by the same laws as the citizenry. So there are basically two categories of American law. There's criminal law that regulates individual conduct, defines crimes and specifies punishments for defendants. And then we have civil law, which basically deals with sorts of interpersonal conflicts. So criminal law, again, regulates conduct. Federal, state, and local governments all have the power to define criminal conduct and to specify punishments. One of the things that's happened in local politics quite a bit has been the problem of homelessness and what can be done at the local level to deal with homelessness. And all too often the problem is that municipal governments will simply roust homeless people from one place and basically, okay, you've encamped in this area, you no longer can do that. So they'll use municipal law basically to run people out, but they don't really solve the problem of homelessness, which is a very complex problem that typically involves a combination of problems. Oftentimes it is related to poverty. Oftentimes there are mental health challenges that are causing people to become homelessness. Oftentimes there are health issues related, that may have provoked. Somebody may have had a health crisis that drove them into bankruptcy. These are basic problems, and it's becoming a problem that is not simply a conservative or a liberal problem. There is homelessness in Tulsa. That was a major issue in the mayoral race this past in 2024. There is a homelessness problem in San Francisco, in Los Angeles. Again, the problem there is that property values are so extremely high that it's very difficult for people to hold on to homes. And so again, you've got this basic problem related to how do you resolve what is really kind of a societal issue that is, our homelessness problem didn't just kind of emerge out of thin air. This is something that has been building up over time. And it's not an issue that's going to be easy to resolve. And again, the question is, do you resolve it by punishing the homeless? Do you really think that's going to resolve the problem by putting them in jail? Again, all too often, you have to identify why these things are occurring and what is the best kind of intervention that will reduce homelessness without necessarily filling up our jails with homeless people. Because it's important, this is an important insight that a UCLA criminologist by the name of Mark Kleeman wrote about. It's called When Brute Force Fails. And the one thing he notes is that the more you criminalize certain kinds of behavior, that is a cost that is going to be borne by society. It costs money to warehouse people. He wrote about this within the context of the war on drugs. The more you put people in jail for drug offenses, the larger your prison population is going to get. So in criminal law, the state is always the plaintiff, and plaintiffs are those persons or entities initiating a criminal prosecution. In criminal matters, there is a separate process. Police investigate crimes and seek to identify and apprehend the person or persons that they believe are responsible. From there, prosecutors then have to make a determination whether the evidence is sufficient to seek an indictment. Okay. Defendants are those people who are alleged to have transgressed against a criminal statute. Most criminal cases in America these days are settled by plea bargains. Plea bargains are a situation where you basically say to a person, we believe you've committed this crime. We will allow you to plead to a lesser crime and receive a lesser sentence in order to avoid the cost of a trial. And again, the point for the state is you are basically saying if you refuse this plea bargain, we are going to come at you with far more severe penalties, far more severe allegations that will lead to much longer time in prison. Most often, people who are apprehended by police, take that deal. But there are instances where people who were simply in the wrong place at the wrong time find themselves bargaining with their lives, where they may not have committed the crime, and yet police believe they did, and prosecutors believe police, and therefore they say, well, we'll put you in prison for 18 months. And a person that may be innocent is confronted with that kind of a deal. Now that points to one of the serious challenges within the legal system. That again, it is very problematical for an innocent person to have to go to jail and then accept that they have now a criminal record, when they may or may not have committed the crime. It's not. I'm not saying that most plea deals are like that, but it happens enough that it does raise serious challenges and serious questions about the equities within our system. And again, it also reflects a challenge that we have in that all too often people who are accused of crimes are also the impoverished. Poverty is one of the more common correlates, for criminal activity. So civil law relates to, again, non-criminal matters. You have contract laws, and that's a situation where a person signs a contract and then there's some claim of suffering because one party or the other has not fulfilled the terms of that legal agreement. An example would be you decide you want to do some home repairs. You have a contractor come to the house, you survey you tell them what you want them to do, and then they give you an estimate. You agree to the estimate. You have effectively formed a contract. Typically, if you're a prudent homeowner, you would not pay everything up front. You would not give them their entire estimate. You would say, I'm going to give you this portion of the estimate, and then I will pay you the balance when I am satisfied. Now, these kinds of things where a contractor will say, I've done your work, and you say, well, I'm not happy with what you've done here. I'm not going to pay you the balance until and unless you make things right. That's the sort of thing that will wind up typically in a small claims court if the amount of money between the two disputants is less than $500. Okay? So that's a basic kind of illustration of contract law. Tort cases involve charges that a person has suffered an injury due to another person or corporation's negligence or bad conduct. Classic example of that was McDonald's ended up losing an enormous settlement to an elderly woman who had spilled coffee in her lap and scalded herself. And her claim was that the materials that they had used to put the coffee in were faulty, and that had led to the spillage and to the injury. McDonald's ended up paying a significant settlement in that. Likewise, another example of a tort. There were two election officials in Georgia who were libeled by Donald Trump's personal attorney, Rudolph Giuliani, in testimony before the Georgia state legislature, where he accused these two ladies of having stolen and manipulated ballot counts in the Atlanta area in Fulton County. They were able to prove that Rudy Giuliani maligned them, that he did not have any basis for the claims that he made. And they won something like $180 million settlement. And he has been compelled to surrender his very expensive apartment in New York City. He's got a very vintage 1980 collector car, jewelry from his time as mayor of New York City that is also worth a great deal of money. All of these things he has been compelled to surrender because he engaged in libel, and because a jury, I believe, or it might have even been a judge awarded the verdict, believed that the penalty had to be severe enough to deter such future libels, especially against people who are doing a public service in acting as an elective official. The third category of civil law refers to administrative law, and again, that involves conflicts over jurisdiction, procedures, or the authority of administrative agencies. The power of the federal courts, there are 25 million cases that are tried in American courts annually. The cases often will range from highly controversial conflicts over basic property, basic rights, to relatively mundane property disputes. And I would hazard the guess that the large bulk of the conflicts revolve around relatively minor issues. In terms of the federal court, the Supreme Court wields, and the federal courts generally wields extraordinary powers. The American political scientist and president, the first president who was a political scientist, Woodrow Wilson, once declared that the Supreme Court is a constitutional convention in continuous session. Now, what did he mean by that? He meant simply that the Supreme Court is basically the final word on the nature and the scope of American civil liberties and of any claims to civil rights that Americans might make in a court of law. Okay? That is an extraordinary power that 9 people on the court enjoy. And it is a power that, historically has been wielded relatively conservatively. They have rarely acted out to strike down actions of the political branches of government. But nevertheless, the Supreme Court of the United States, otherwise known as SCOTUS, is uniquely positioned to interpret the Constitution. In saying what the Constitution is, they are also in a position to say what it is not. For example, in the Dobbs versus Jackson women's health decision in summer of 2022, the Supreme Court basically held that the Constitution does not confer a right to reproductive freedom to women. Samuel Alito basically said it wasn't written in it, it was never implied. Now, he also basically ignored the Ninth Amendment, which says that there are rights and liberties that are not to be construed by listing out the rights in the Bill of Rights as not existing. Samuel Alito apparently doesn't agree that the Ninth Amendment has any relevance on that. As the size and scope of the federal government has expanded, the power of the federal judiciary to rule on the constitutionality of laws and executive actions has taken on a heightened importance. So, in an important sense, who gets to name the judges and justices? That goes a long way towards determining the nature of our laws. Precedence is very important, okay? America follows the English common law tradition, which means you decide cases and then precedents flow from those earlier decisions. So courts apply statutes and abide by prior decisions. Okay, precedents established in previous cases generally will guide courts' decisions in new cases, unless a judge makes a determination that a case is a matter of first impression, which is to say that the judge is basically declaring that a particular case is novel and does not have a clear precedent to guide their actions or guide their decision making. Under the legal principle of stare decisis, which is Latin for let the decision stand, courts are obliged to apply precedent or to identify a reason why precedent does or does not hold or should be reversed. As part of America's commitment to rule of law. American rule of law basically flows from this idea that we don't just throw everything up in the air with each new case. There are a variety of types of courts. The federal and state legal systems have different levels. They are shaped roughly like a pyramid. More than 97% of all court cases are handled in state courts, which again reflects the sense that there are 50 states and they all kind of have their own codes of justice. Most civil and criminal cases are settled via plea bargains, and I mentioned what a plea bargain involves. Cases originating in trial courts oftentimes are generally held before a judge. Occasionally, oftentimes, you'll have a jury of peers that will be impaneled to hear a case and render a verdict. The idea that you have trial by a jury of your peers is an essential feature of American jurisprudence. There are times when a defendant may agree to what is known as a bench trial, where basically the judge will determine guilt or innocence and assign a penalty. In the event of a conviction, defendants may appeal to a higher court, also known as courts of appeals. Both the federal and state judiciaries have courts of appeal. The federal and state Supreme Courts are the courts of last resort. And again, there's a famous Justice Robert Jackson who basically made the statement, the Supreme Court is not infallible because it's final. It's final because it's nevertheless final. I got that wrong, but that you understand what I'm saying. In other words, there typically is not an appeal beyond the Supreme Court once you have had a case heard there. The U.S. court system, again, this kind of shows you how you're going to deal with with any particular case. In most instances, you've got 95 districts in the federal courts. States also, again, have trial courts or superior or circuit courts. Then you have intermediate courts. There are 12 circuit courts of appeals. And then finally, things go all the way up to the Supreme Court. When you look at actually the different circuits, this is the intermediate layer within the federal government. The 1st, 2nd, and 3rd districts deal mostly with the northeast. The 11th district deals with the deep south. The 5th district also encompasses portions of the deep south. If you look at this map, Oklahoma is part of the 10th Circuit Court of Appeals. And that is mainly sort of relatively sparsely populated states, just outside the Midwest. The 8th Circuit deals with the 7th and 8th, and really the 6th Circuit deals with much of the Midwest. And then you look at that 9th Circuit, it is an enormous expanse of territory with an enormous amount of population that is mainly loaded on the West Coast. There have been arguments that the Ninth Circuit should be broken up, probably into two, where you would have one district, one circuit be Oregon, Washington, Idaho, and Montana, and then the lower portion remain in the Ninth Circuit. The Fifth Circuit has established a reputation of being the most conservative circuit court. The 4th District is often described as the rocket docket because they simply do not tolerate delays in trials. They insist on things moving very rapidly. Jurisdiction is an important concept to grasp in understanding the role of judicial process. Jurisdiction refers to the space in which a court has power and authority. Okay? Federal courts have jurisdiction over the enforcement of federal laws, treaties with other nations, or issues related to the Constitution. The 94 district courts, federal district courts, are basically divided via geography. Every state has at least one, district court. It kind of reflects, again, the geographic area. Circuit courts of appeals are organized into 11 regional circuits along with the D.C. Circuit. And the D.C. Circuit, again, gets a lot of business. It's often considered to be a stepping stone to the Supreme Court because a lot of high-profile federal issues are resolved in the D.C. Circuit. Article 3 of the Constitution gives the Supreme Court original jurisdiction over 4 specific cases, kinds of cases. The Supreme Court's original jurisdiction includes cases between the United States and one of the states, cases between 2 or more states, cases involving foreign ambassadors or other ministries, and the 4th category is cases brought by one state against citizens of another state or against a foreign country. The Constitution grants the Supreme Court appellate jurisdiction in all federal cases, and most cases adjudicated by the Supreme Court arrive via its appellate jurisdiction. Now, there is a part of the Constitution, it has been rarely employed, that is known as venue stripping, where Congress basically has the power to limit the court's jurisdiction over certain matters. The most famous instance where that happened happened during the Civil War, where the Supreme Court was effectively sidelined by Congress because the court had a number of Confederate sympathizers on the court, including the Chief Justice Roger Taney. And they basically removed issues related to habeas corpus because, again, one of the war measures that the Union had to undertake was basically arresting a number of people who were known to be Confederate sympathizers. Due process is another very important aspect, a concept of judicial process. The appellate process is an essential feature of the just administration of the laws. It's designed to ensure that wrongful convictions can be appealed and vacated. Defendants convicted in state court may request a writ of habeas corpus from a federal district court under certain conditions. This is sometimes known as the Great Writ. Habeas corpus is Latin for "you have the body." In legal terms, it means that it is basically a court order that an individual held in custody be brought into court and shown the cause for their detention. The right to file a habeas corpus petition is guaranteed by the Constitution and can only be suspended in cases of rebellion, i.e. the Civil War, or invasion. Defendants in those kinds of instances must show that they have exhausted all available state remedies and must raise the issue, raise issues not previously raised in their state appeals. Federal courts of appeal and the Supreme Court have appellate authority for federal district court decisions on those kinds of petitions. So when federal courts hear only a small fraction of the civil and criminal cases decided, nevertheless, when they do, they are setting an example, and they are demonstrating to federal and state courts that this is how they believe the laws ought to be interpreted, and that they should follow Supreme Court precedent in those situations. Okay, our second topic, the federal courts hear a small percentage of all cases, which again is not surprising. The federal law, while it is voluminous, is relatively small compared to state criminal law. Okay, federal courts, again, in 2019, federal district courts received over 390,000 cases, which is 3% of the number of cases heard in state courts. The federal courts of appeal received 48,486 cases, which is again 12% of all the district court cases. And roughly 6,500 or 15% of circuit court rulings were appealed to the Supreme Court. Now, this is an important aspect of the Supreme Court's jurisdiction. Up until well into the 20th century, the Supreme Court was obliged to at least hold pro forma hearings on all cases that appeared before them. But as the size of the federal government expanded, that became increasingly unworkable. And this is another one of those laws that was passed in the early 20th century that had a profound effect on the workings of the federal law. The Judiciary Act of 1925 basically gave the Supreme Court broad latitude to accept or reject cases. This is also known as the Judge's Bill. It was a result of a study appointed by then Chief Justice William Howard Taft, who was also, this is a trivia thing, William Howard Taft is the only person to have served as both President of the United States and as Chief Justice of the Supreme Court. The three justices Taft appointed to the commission, Willis Van Deventer, James Clark McReynolds, and George Sutherland, worked closely with Congress in kind of forming a law. And as a result of the law, the Supreme Court retained mandatory oversight on cases which raised questions involving federal jurisdiction. The bill created what is known as the certiorari process. A writ of certiorari is basically a court order saying they intend to take up an appeal. It's basically a writ of certiorari is Latin for to be more certain. And that allows basically the court to pick and choose which cases it's going to hear and which court cases it will decline. Up until around the 21st century, the court routinely would adjudicate up to 120 cases per judicial session. These days, they rarely take on more than 75 or so. So over the course of the Rehnquist, who was the previous Supreme Court Chief Justice, and the Roberts courts, and John Roberts is the current Chief Justice, fewer than 100 cases per year have received full scrutiny by the Supreme Court. And again, what that basically means is when the court refuses a writ of certiorari, they are basically saying that the decision of that lower court is upheld. So again, the composition of federal trial, appellate, and Supreme Courts. You have the federal trial courts. There are 94 district courts that originate any legal process involving federal law. Congress has authorized the appointment of 687 district judges. District judges are appointed according to workload. The busiest courts in the most highly urbanized states, like New York City or Chicago, will have as many as 28 federal circuit judges. In most instances, cases are assigned to a single judge, except where statutes provide for a 3-judge panel to deal with special cases. For the federal appellate courts, around 20% of all lower court cases are reviewed by federal appeals courts. Congress has authorized, our circuit court as circuit court judges. Each circuit court of appeals has 6 to 28 permanent judges. They typically sit in 3-judge panels. In some instances, particularly following an adverse judgment from a 3-judge panel, a party may seek what is known as an en banc appeal of the entire circuit. Another important layer of review involves a Supreme Court justice sitting over each circuit court, and they handle requests for special action by the Supreme Court. This oftentimes is what we call a shadow docket. The Supreme Court, Article 3, vests the judicial power. And again, this is one of these vague, the vesting clause. Does it really mean judicial review or doesn't it? We're not really sure. Nevertheless, Article 3 has a vesting clause just like Articles 1 and 2, and it vests the judicial power of the United States in a Supreme Court. Supreme Court is the only federal court established by the Constitution. Lower courts are basically created by Congress and can be restructured or abolished by congressional statute. The Supreme Court's composition is determined by Congress. The size of the Supreme Court over the course of the 19th century was 6 for a period of time, then 5, then 7, then 9, and in 1863, the court size was expanded to 10. In 1869, the Circuit Judges Act set the composition of the Supreme Court at 9, where it has remained ever since. Now again, currently, the Supreme Court is dominated by justices who were appointed by Republican presidents. It is a conservative court, and a lot of liberals have argued that they should expand the number of justices. Personally, I think I would like to see an expansion of the court. I would like to see the court expanded to 36. And then have each instance where you have a writ of certiorari ordered by the court, where 9 justices be randomly drawn from that 36, and so you would get a variety of different justices. And I would also have it set to where neither party would be able to have a more than a 2-judge advantage, so that you would be pulling from a random selection of liberal and conservative judges. Because right now, our polarization has reached a point where, frankly, it matters more who appoints the judges than what is being done by the judges. I really feel at this point that the judicial process is being politicized in ways that is undermining the commitment to rule of law. That's just my view. You're welcome to disagree with me. So how are judges appointed? Federal judges and justices, first and foremost, have to be nominated by the president. Okay, that is a situation, first and foremost, where you have a strong presumption that the president wants to appoint people who reflect his ideological commitments and his basically programmatic commitments. And generally speaking, a president is going to look at their legacy as who they are able to put on the Supreme Court, because those are people who can serve for decades beyond a president's terms of office. Okay? The president and the president's party play a significant role in identifying likely candidates. And historically, most of the people who have been appointed to the Supreme Court have been practicing lawyers and have been people who have served at least on one of the circuit courts. Most often in recent years, they have been coming from the D.C. Circuit Court of Appeals. It has happened where you've had governors selected to be members of Earl Warren, one of the chief justices from the middle of the 20th century, was a Republican governor of California and had been Attorney General of California during World War II. You've also had former solicitors generals like Elena Kagan, who was also the dean of the Harvard Law School for a long time. She is now a current justice. Presidential nominations are again subject to the advice and consent authority of the Senate. That typically means that once a president has nominated a person to serve on the Supreme Court, that their nomination will go to the Judiciary Committee, where they will face questioning from the members of the committee. And again, it is oftentimes an adversarial process in these days, because again, this is a high-stakes situation. Both sides recognize that getting a person on the court is tremendously high stakes. The members of the other party, if they think that a nominee is too extreme in one direction or another, will try to tank that in hopes that the next person that the president nominates will be less extreme. It's also important to keep in mind that members, of the people who are nominated to become federal judges and justices of the Supreme Court go through a fairly extensive vetting process where the FBI looks into their finances, looks into any possibility that they might have conflicts of interest. Okay? There are no formal qualifications for a person to serve on the Supreme Court or as a federal judge. But there are a lot of kind of informal expectations. So in the past, administrations have talked to the White House Office of Legal Counsel, who identify potential lists of candidates for judicial nominations. While the Constitution, again, is silent on qualifications, likely judicial nominees at minimum typically have earned a Juris Doctorate, have practiced law, and have developed a reputation for legal excellence. Donald Trump, in his first term, essentially appears to have outsourced the recruitment process to the Federalist Society, where one person by the name of Leonard Leo, a former vice president of the Federalist Society, led the effort to identify and secure confirmation for basically Federalist Society judges, people who adhere to the ideology of the Federalist Society. So particularly in instances where the Senate and the president are held by the opposite party, the Senate majority has incentives to slow down judicial nominations. By tradition, the Senate is allowed, has basically allowed district court, lower court nominations to go through as a matter of course, and have generally reserved opposition for particularly, offensive nominations to the Circuit Court and the Supreme Court, and they generally have done that relatively sparingly. However, by the early 2000s, the norms restraining Senate rejections of judicial nominations had basically broken down, and both parties have used the filibuster to slow down or stop the nomination process in hopes that the election of a president, of a different president, or a change in the Senate's majority would have, would basically create a backlog. And that's actually something that happened, again in 2016. Republicans took control of the Senate in 2014, and they basically filibustered everything. They basically just stopped doing nominations for Barack Obama. And when Antonin Scalia suddenly died early in 2016, and Barack Obama nominated Merrick Garland to be the Supreme Court justice to replace Alito, Majority Leader Mitch McConnell basically said, we won't even hold hearings on him. His nomination is dead on arrival. And that again reflects the sense in which, politics is being played in an extremely ruthless manner. And you could make the argument, again, the campaign process really hadn't begun. It was in early March that Obama nominated Merrick Garland. The election wasn't until November. They were willing to allow the court to be a person short, and just running with 8 justices for well into a year, because I don't believe Neil Gorsuch was confirmed until something like February or March of 2017. So again, that reflects a sense in which advice and consent is increasingly being wielded in relatively ruthless ways. So it's increasingly a zero-sum game. This is, judicial confirmations. Again, you're putting people on, into federal judgeships, potentially for life under good behavior. And the Senate's confirmation authority is frequently being used to slow that down. And that's one of the things that's happening in the waning months, because remember, Democrats still control the Senate until Inauguration Day, until the new Congress is sworn in. And so right now, the priority of Senate Democrats is to get as many of Joe Biden's judicial nominations confirmed to district and circuit court positions as possible, so that they don't leave a backlog of those positions to be filled by Donald Trump. Because again, the argument is Donald Trump used those nominations to further partisan to partisan ends in terms of loading the court with people who were ideologically aligned with the Republican Party, rather than caring more about the rule of law. So again, another example of this is the nuclear option. Democrats invoked the nuclear option in 2013 to stop Republicans filibustering Obama's appointments. That enabled Barack Obama to appoint more than 300 district court and 55 circuit court judges. And of course, Republicans warned that if you do this, it will come back to haunt you. In 2017, the Republicans extended the filibuster ban on 2 Supreme Court nominees, enabling President Trump again to make 3 Supreme Court appointments. And he'll likely have an opportunity to appoint more, because 2 of the conservative justices, Samuel Alito and Clarence Thomas, are both well into their 70s. I can't remember how old Clarence Thomas is, but he's the longest serving justice as well. Supreme Court appointments, political factors are decisive when it comes to Supreme Court appointments. Supreme Court nominations offer presidents a unique opportunity to establish a long-standing legacy likely to survive their terms of office, potentially by decades. 6 of the 9 current justices of the Supreme Court as of October 2020 were appointed by Republican presidents. That remains the case. Actually, we've had one other replacement, but that was basically a liberal, Stephen Breyer, a Clinton appointee, being replaced by Ketanji Brown Jackson, a Biden appointee. Conservatives have enjoyed a majority on the court for 47 years. The exception was 14 months between the death of Associate Justice Antonin Scalia in February 2016 and the confirmation of Associate Justice Neil Gorsuch in April of 2017. For that period, a 4-4 split prevailed between the judicial conservatives and the liberals. Going back to the 1980s, Supreme Court nominations have involved intense partisan struggle. Again, there was a book written by a guy named Stephen Carter, basically called The Confirmation Mess. And he basically said, you know, this has become increasingly a fiercely contested partisan fight. Partisanship is destroying the court. It is undermining faith in the courts. And that, you know, nothing has changed since that book was written in the 1990s. So again, once a president nominates a prospective justice, interest groups supporting or opposed to the nomination mobilize opposition in the media. They spend hundreds of millions of dollars attacking these folks. It's really gotten to be an ugly process for the nominees and their families. The process that Ketanji Brown Jackson went through was horrific in my view. Some of the accusations that were leveled against her were completely unwarranted. But again, that is part and parcel now of the process. And again, famously, Antonin Scalia's sudden death early in 2016. When it happened, I was sitting with my wife and we were watching the news, and I was like, "Oh, that's going to be ugly." And it turned out to be ugly because I really think that the Senate in basically having that 14-month refusal to engage in their constitutional duty was a problem. It set a precedent. If there are no replacements on the court, and in 2026, Democrats win control of the Senate, and someone dies on the court, or is somehow otherwise removed, Democrats will then say, we have a precedent, we're not going to allow Donald Trump to fill that position. That's simply how it's going to be, and it's unfortunate. It shouldn't be this partisan, but it is. So again, that is the challenge that we confront. Now, regarding the Scalia thing, Mitch McConnell's rationale was that the nomination should be made by the winner of the 2016 presidential election. And that was subsequently belied when McConnell forced through the nomination of Amy Coney Barrett following the death of Associate Justice Ruth Bader Ginsburg, who died just literally days prior to the 2020 presidential election. This is the current Supreme Court by order of seniority. Again, if you look, Clarence Thomas has served on the court since 1991. Do the math on that. That is 30-something years. John Roberts has been on the court since 2005. Samuel Alito followed in 2006. Sonia Sotomayor was added to the court in 2009, Elena Kagan in 2010. And then you get 3 consecutive justices appointed by Donald Trump, Neil Gorsuch in 2017, Brett Kavanaugh in 2018, and Amy Coney Barrett in 2020. And then finally, Ketanji Brown Jackson became the first black woman to be appointed to the court. And again, this was a situation where Joe Biden made a promise that he would nominate a black woman to the Supreme Court if he got an appointment. Republicans excoriated Biden, basically making the argument that any person that he picked would be a DEI hire. And this has become, DEI is an acronym for diversity, equity, and inclusion. Nobody has questioned Ketanji Brown's qualifications. She graduated from Harvard with high honors. She has served on the Circuit Court of Appeals for a long time. She had been a district judge for a long time. She has been viewed by most as a very sober and frankly, a brilliant jurist. Nevertheless, she was attacked in the most personal terms. Some of her decisions, basically making it sound like she was coddling child abusers and things like that. It was really a grotesque process, and I doubt that it will improve if another opening comes up in the coming term. Our third topic: the power of the Supreme Court is judicial review. Judicial review is one of these very significant authorities that gives the Supreme Court the power to say what is and is not constitutional. Okay? Andrew Jackson, former president of the 19th century, basically said, "All rights secured to citizens under the Constitution are worth nothing, and a mere bubble except guaranteed to them by an independent and virtuous judiciary." Without that sense in which the Supreme Court acts, basically as a non-political referee, you're going to get you're going to get a sense in which the law can be used as a partisan cudgel. Okay. And this has far-reaching implications. One of the things, I love watching football. And it has increasingly gotten to the point where even during football games, you get these accusations by the losing side that the referees put their thumb on the scale for the winner. I mean, this is, in the broad scale of things, how a football game turns out is trivial. But to the extent that we're seeing these kinds of manifestations, there was a near riot during a football game, between two highly ranked teams, Georgia and Texas, where literally the Texas fans, threw bottles onto the field, caused a stoppage in the game, and then the officials reversed the call, which basically encourages fans, home fans, to basically engage in disruptions in order to get their way. That is so toxic for just the good of the game, first and foremost. But more importantly, it is sort of the canary in the coal mine for how Americans are losing their sense in which rule of law matters more than their own ability to work their will through the electoral process. Democracy only can sustain itself to the extent that all parties accept that adverse outcomes can be overcome in the long term, and that they benefit more by abiding by the results than by seeking to use violence or some extrajudicial or extra-legal means to overturn the outcome. So judicial review refers to the power of the judiciary to scrutinize actions of the legislative and executive branch and state governments to determine whether those actions are in accord with the Constitution. Now again, you have the very ambiguous nature of Article 3's vesting clause. Article 3, Section 1 states, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuation in office." Now, some delegates assumed the judicial power implied judicial review. Others, which were known as departmentalists at the time, believed each branch of government would interpret the Constitution as it applied to that branch. Now, the departmentalists lost, and they were well vanquished because, frankly, that would have been a recipe for basically the inability to govern. It would have been a recipe for anarchy. But nevertheless, there are a number of very important things. First and foremost is this idea of vesting judicial power. And what does the judicial power mean? Secondly, it reflects this idea that judges once appointed and confirmed cannot be removed by any political action other than impeachment. So there has to be, again, a clear indication that leads to an impeachment process, that a judge or justice has engaged in what are the three big things: treason, bribery, or other high crimes and misdemeanors. Now, judges, I think about 17 judges have been impeached and removed over the course of our history, so it hasn't been used very often. The most common allegation is bribery, the use of their office for some personal gain. But it's conceivable that a judge could be removed for other high crimes and misdemeanors, such as, again, committing a felony like rape or murder, or a misdemeanor to the extent that a person is habitually drunk while presiding over a trial, or simple senility. Okay, impeachment has been threatened. William O. Douglas was a famous example of a justice that continued well into their, I believe, into their 90s, and reached a point where they simply were not capable of performing their duties as a judge any longer. So the role of judicial review was established and sort of resolved in the acceptance of the court's decision in Marbury versus Madison. Now, Marbury versus Madison revolved around actions taken. Again, we're dealing with a similar situation right now. As I shoot this video, we are in between elections, right? We have had an election where Republicans have regained unified control of government. However, in the current government, you have a rump Congress and administration continuing in power until January. Okay, right now it's November. The same situation happened in 1800, where the Adams administration got swamped. They got devastated in the elections of 1800. The Federalists were basically swept out of power. Nevertheless, they held power because back in those days, inauguration wasn't until March. Okay, and so Adams and Federalists in Congress got busy, and they basically created a bunch of new judicial departments, a bunch of new districts, for people to, for judges to serve in, and they appointed a bunch of judges and justices. Okay, and a lot of those commissions, again, somebody gives you a president signs off on a commission that then gets delivered to a judge, and that means that person is then a judge back in those days. A number of those commissions were not delivered. That ended up in a situation where one of the judges that knew he had been appointed and confirmed by the Senate went and sued the incoming administration of Thomas Jefferson, saying, I want my commission. And James Madison, who was the Secretary of State for Thomas Jefferson and who was the officer that was supposed to deliver those outstanding commissions, basically refused. William Marbury sued basically James Madison. That's how you get Marbury versus Madison. William Marbury was one of those Federalist supporters who had been appointed as a federal district judge. So the whole case revolves around the idea of can the Supreme Court issue what is known as a writ of mandamus to compel James Madison to deliver that commission. Now, in all likelihood, the commissions had been destroyed, and the members of the Supreme Court knew that. And they also knew they had very little actual power to make James Madison do something that he was not inclined and may not have been able to do. That Jefferson had basically ordered him not to deliver those commissions. So the person sitting on the Supreme Court, and this is kind of ironic, was John Marshall. John Marshall was related to James Madison. John Marshall was a Federalist. He had actually served as Secretary of State under John Adams. He was the guy that didn't deliver the commissions because he was so busy getting ready to become Chief Justice of the Supreme Court. And so in contemporary politics, this would have never been, he would have had to recuse himself, I would think, because it would have been viewed and decried rightfully so as an intolerable conflict of interest. Nevertheless, you have a situation where John Marshall wants to compel these guys to issue a writ of mandamus, but he can't. And so what does he do? He basically invokes the power of judicial review to say that the Judiciary Act of 1801 was an unconstitutional violation of the separation of powers. So an act that the Jefferson administration didn't like, a portion of it was struck down. And it basically asserted for the court that power of judicial review. It is the province of the court to say what the Constitution is and is not. And that was because, again, it was an assertion that couldn't be rejected, that there was no positive action that the executive branch could undertake that they could defy, right? So that is why we have judicial review today. Now, generally speaking, you have to understand that the reason why judicial review persists is because the Supreme Court has generally used it sparingly. They have worked hard to avoid overly antagonizing the political branches of government, because those political branches of government have authorities that can rein in a court that becomes a star chamber and becomes removed from the public will and acts persistently in offense against the public will. A good example of the kind of the contemporary way that the court kind of manages these political challenges is the National Federation of Businesses versus Sebelius, which was handed down in 2012. This is a case revolving around the Affordable Care Act. Conservative interest groups challenged the Affordable Care Act on several grounds, basically arguing that it was an unconstitutional law on a variety of bases. The legal implications for the healthcare system and for federalism were significant. And in fact, one of the reasons why the Obama administration drafted the Affordable Care Act the way they did was to try and be elaborately respectful of federalism as a principle. And remember our earlier discussions of federalism. So the conservative justices on the court at the time wanted to strike down the Affordable Care Act in total. Chief Justice John Roberts recognized that in that current environment that would probably be a problem. And so he crafted a compromised ruling. Conservative legal scholars and interest groups argued that Congress had exceeded its authority under the Commerce Clause by imposing a mandate on Americans to purchase health insurance or pay a fine. Now, this was one of the conservative aspects of the Affordable Care Act. And I want you to understand something. Congress and people, think tanks in Washington, D.C., have been thinking about health care and have been drafting health care legislation for close to 40 years. Okay, what the Obama administration and Democrats in Congress focused on in 2010 was a relatively conservative version of health care reform. Okay, and again, what was the purpose behind the Affordable Care Act? It was to expand the access of low-income Americans to some kind of meaningful health care. There were over 40 million Americans that didn't have any kind of health care. Okay, so Chief Justice Roberts basically upheld the constitutionally the mandate by basically saying that the language of the law was irrelevant, that it was a tax rather than a fine. However, Roberts' decision also struck down a provision of the Affordable Care Act that mandated significant expansion of Medicaid. It basically made it so that the states could refuse Medicaid expansion. And I want to emphasize here that Medicaid expansion, the portion of the Affordable Care Act, was designed to be too good of a deal for conservative states to refuse. Conservative states like Oklahoma rejected Medicaid expansion. Eventually, citizens put it on the ballot by initiative and got that. Okay, they forced the state of Oklahoma to accept Medicaid expansion. So again, that created kind of an all or nothing choice on state governments. Accept Medicaid, the Medicaid program, or lose Medicaid funding altogether. For Roberts, he said that's not acceptable. You have to continue providing access to Medicaid, but you can't compel them to do the expansion. And so ultimately, that compromise has allowed the Affordable Care Act to persist. And in fact, at this point, the Affordable Care Act is sufficiently popular. It was, they were successful. Republicans failed. They tried over 63 times, I believe, to overturn the Affordable Care Act. But at this point, the Affordable Care Act is the structure of our health care system. If you're going to repeal it, you have to replace it with something. And so that has been the challenge. Again, when Republicans did try to do it, when they started cooking up plans to replace the Affordable Care Act, everything that they came up with was basically just a modulation of what already existed. And that's one of the reasons why some conservatives in Congress were saying, let's just repeal it. Hard repeal, no replace. And most healthcare experts, warned that would have been a really bad outcome. That would have created a terrible situation. Okay, so in more than 2 centuries, the court has basically rejected fewer than 160 acts of Congress or executive actions as somehow directly violating the Constitution. Judicial review of state actions. Again, the power of the Supreme Court to review the constitutionality of state legislation and other state agencies is implied under Article 6's Supremacy Clause. Basically, if Article 6 says that the Constitution is supreme, and if the Supreme Court has the power to interpret the Constitution, by extension they have the power to review state actions. Under the Judiciary Act of 1789, Congress delegated the authority to reverse state constitutions and laws whenever they are clearly in conflict with the U.S. Constitution, with federal laws or treaties. Article 6 further binds state judges to the Constitution, federal laws, and or federal treaties. The Supreme Court frequently monitors state law enforcement, and the court has developed numerous principles to ensure police conduct does not violate constitutional liberties. For example, in a 2012 decision, the Supreme Court found that the police use of GPS trackers constituted a search as defined by the Fourth Amendment and therefore required a warrant. Additionally, in Riley versus California in 2014, the court ruled that police could not undertake a warrantless search of digital contents of a cell phone without permission or without a warrant. Okay. They have also, again, they are part of and parcel of consent decrees. For example, there are numerous municipal governments these days that have been placed under consent decrees because of situations where police have habitually violated the constitutional rights of victims. So again, that is part of the process. Let's look at the court in comparison, okay? If you look again at different countries, they deal with 4 dimensions of judicial process differently. For example, the Chilean court, they have term limits. They don't have a mandatory retirement age. Their size is set at 9, probably following the United States. And each branch of their government appoints some justices to the court. Now, again, I think the design there is to ensure that the court doesn't get captured by one partisan group like ours is. The French Constitutional Court, again, term limits, only 9 years. There is no mandatory retirement age, but there is a size, again, set at 9. And again, each branch appoints some justices. The German Constitutional Court, there is a 12-year term limit. Their mandatory retirement age is 68. They have 18 members of the Constitutional Court. The legislature determines who will serve on the court. The High Court of Australia follows the United States in having life tenure. They have a mandatory retirement age of 70. They only have 7 members, and the executive selects. Okay? The Indian High Court, life tenure, but mandatory retirement age is 65. The court is 28. There are 28 members of the Indian Supreme Court, and again, the executive selects. The South African Court, again, when you look at all these things, I think we should have a mandatory retirement age. I think 72 would work. I think that would be fair. I think we should expand the court. Like I said, I think we should ensure, that we should have a bipartisan Supreme Court nominating commission. I would love to see something like that done, where, again, a commission appoints, they select a number of people that are based on merit rather than on ideology. And again, that person then, you can allow the president to select someone from that group. Judicial review of federal agency actions, the rise again of the administrative state to administer the thousands of federal programs significantly increases the amount of administrative discretion available to people. Now, one thing that has happened, the idea of Chevron deference, which is basically dealt with a case in Chevron USA versus Natural Resources Defense Council. This was a 1984 decision where basically the court held that the scope of administrative discretion is such that the courts should be deferential as long as rules proposed by an agency do not violate Congress's express or implied intent. Now, that ruling has subsequently been overturned. That was overturned in the last judicial session. Again, many conservatives believe that the court's deference to bureaucratic agency is excessive and administrative discretion needs to be sharply curtailed. The court used what is known as the major cases doctrine basically to say that Chevron deference is excessive and that Congress, if they want to give regulatory authority to an executive branch agency, they need to do so more explicitly. Judicial review and presidential power. The judiciary typically upholds assertion of presidential power in such realms as foreign policy, war, and emergency powers. Okay, and this is something that's undoubtedly going to come up in the opening months of the Trump administration. He has basically signaled that he is going to assert an emergency regarding immigration, and then he is going to try to deploy the military to engage in a mass roundup of undocumented immigrants. Now, 2 important cases illustrate the scope of presidential authority in the realm of foreign policy. In a 1930 case, the United States versus Curtiss-Wright Export Corporation, the Supreme Court upheld the president's authority to impose an arms embargo in attempting to resolve a war between Paraguay and Bolivia. The court ruled that the President of the United States was the sole organ of foreign policy and that corporations had to obey presidential orders like an embargo. However, in Youngstown Sheet and Tube Corporation versus Sawyer in 1952, the court struck down President Harry Truman's executive order seizing American steel mills during the Korean War, arguing that the president lacked the authority to seize the steel mills in the absence of congressional authorization. So again, that creates a kind of a zone where you can see where presidents have considerable authority and where there are limits. Okay, the Bush administration's war on terror produced several Supreme Court decisions placing limitations on presidential authority. For example, in Hamdi versus Rumsfeld in 2004, the Supreme Court ruled that Yasser Issam Hamdi, as an American-born citizen, was entitled to a lawyer and a fair opportunity to rebut the government's factual assertions. While the court asserted that it could review and place some constraints on the president's powers, it also affirmed that the president had unilateral power to declare individuals, including U.S. citizens, as enemy combatants who could be detained under adverse legal circumstances. The Supreme Court also held that President Obama's attempt to use recess appointments to the National Labor Relations Board violated the Constitution, holding that the Senate makes their rules and they get to say whether they're in session or not. So pro forma cessions were considered constitutional. And then finally in 2018, the Supreme Court upheld Donald Trump's travel ban on people traveling from Muslim majority countries. Again, in that instance, the minority basically said, Trump said this was a Muslim ban. You're trying to say it's not by using an act of judicial opacity. Nevertheless, presidents have exceptional powers when it comes to interpreting immigration laws. So that's all we have time for today. When we come back, we will continue our discussion of the judiciary and the federal courts. I'll see you next time.